the twists and turns. I don't know where you want to take it from. There are just too many issues around it.
Yes, something true. There's been a lot of twists and turns, and it is true also that we see a situation where the whole judicial process regarding the petition that is supposed to be determined to determine whether the Chief Justice should remain in office or not has been politicized, and so it creates a very bad scene, especially for law students who want to know the law and know the processes involved in many or several legal situations that may come up. And so it's very unfortunate that this has been the turn of events. Be that as it may, I think that we have to look at what the Constitution is saying and to be able to abide by the tenets of the Constitution. I see a situation where the law is clear on the face of it, and so you need to go by the black letter interpretation of it in some ways, but also there's an attempt to go by the purposive interpretation approach and to seek to sort of redesign the Constitution more or less to be able to ensure that justice is served. And so at the end of the day, where we are now, it looks like we have to let the process work. And so my view on it is that unless we get to the bottom of this, we'll not be able to know how this whole process will end up. There seems to be some misinterpretation that this is an attempt to remove the Chief Justice, but I don't think we should see it that way. There is a process in place, and at the end of the day, the result could be the Chief Justice is removed or she's not. And I think the issue about the suspension has also led to a situation where some have concluded that if there's a suspension, there's definitely the Chief Justice is going to be removed. So that interpretation, I think, is wrong, and it's unfortunate that some seasoned lawyers are making that interpretation, and which has caught on with some political followers, and therefore it has led to the clear politicization of the matter. So that issue, the case as it is now, should be allowed to work. I think that the decision, the most recent step in the whole process where a writ has been issued, to my mind, is unfortunate. And it looks like we want to really drag the matter in a way that will muddy the waters. It's unfortunate. I see clearly that there's some kind of some discord or mistrust within among the Supreme Court justices themselves, looking at the way the suspended Chief Justice is trying to suggest that the members on the committee can be biased, and therefore they cannot sit on the committee. So all these things imply that the whole process has been politicized. And I can also conclude that the justices themselves, in a way, have been politicized. And so there seems to be people taking sides based on, with some political color involved in it. On the part of the Attorney General, I also see some contradictions or contrary behaviors. The former Attorney General, because the posture he took when he was the Attorney General and where he is right now, it seems to me contradictory, and it's actually confusing to me. When he was the Attorney General, we know some of the decisions he made, some of the unethical issues that were involved or connected with some of the cases he did. He seems to be on a different path now, seeking for redesigning, reinterpretation of the Constitution to make sure that justice is served for the Chief Justice. And so at the end of the day, I don't really know where he stands and what he wants to achieve by this. Of course, on one side, we see that he wants to ensure that the Chief Justice is restored to her position, and then the whole process is abrogated. But my question is, to what purpose? Is it, in what way is this case and the way he's approaching it going to help in the jurisprudence of the Supreme Court, and how we as learners of the law and especially students of the law can learn from it? That will help them to learn about constitutional law, administrative law issues, even human rights related issues. And so at the end of the day, we need to be cautious how we let politics enter into the legal arena, so that we can learn something out of it in a way that will improve the study of the law. Of course, it's at the end of the day, justice needs to be served. And I think that the processes, as has been outlined in the Constitution, that do not completely take justice out of the hands of the Chief Justice. And so I think that the processes should be allowed to serve its course. And at the end of the day, we'll be able to know what happens out of it. We have already mentioned that the process as it is not fair, but that is what we have now as the Constitution, and we need to respect that.
So first, you say a couple of things that I'm left wondering. Are you saying that the Chief Justice does not have a right, when she feels that her rights are being violated, to approach the Supreme Court and ventilate her rights? So why is it unfortunate that she has gone to court? Is that not what civilized people do?
Definitely. I'm not disputing or contesting the fact that the Chief Justice has a right to demand that her rights are respected. That is certainly the case. And so one cannot necessarily question what she's trying to do. She has a right to do that. But what I'm saying is that we should make the system work in the way that when something wrong has been done, we will make sure that while we seek to ensure that we get justice served, we also have to look at the processes carefully. And when we want to question it, we should have a firm basis for doing that.
Your point was that she's seeking to frustrate the process, but she's seeking to ventilate her rights. That's what she's saying.
I think that it's about frustrating the process. And that is why where my concern is.
Is that a fair comment to her, that she feels her rights are being violated and she's seeking to ventilate her rights, assert them, and you say that it's just an attempt to frustrate the process?
The Chief Justice has a right. I already indicated that. And she has a right to question the process every step of the way. But at the same time, some of the steps that are being taken are meant to frustrate the process. For example, if you look at the question of injunction, the injunction has been thrown in here and there. First, to injunct the Council of State, the President, the Council of States, when the issue of prima facie issue came up, even when the President had said that, okay, Chief Justice, submit your petition, your response to the petition, the matter still remained at the Supreme Court. And now they are questioning placing under injunction the way of the committee and questioning the qualification of some of her colleagues to sit on the matter. And that's why I'm saying that there is some issue about the fraternity and the camaraderie that are supposed to reign among members of the Supreme Court. And so if that is really something that is missing, then there's an issue there with the Supreme Court. But the bottom line is that if you look at the way all these processes are being thrown in. Now a writ hasn't been issued, and so on. I think that's an attempt to frustrate the process. The call for public hearing, when I think it's clear that the Constitution says the committee shall sit in camera, then what is the justification for asking for the process to be changed so that there'll be a public hearing? These are the issues that I think are being thrown in to frustrate the process, maybe to delay the process. And I don't know what's the final outcome that may arrive.
In respect of the issue of the public hearing, we have heard people like Professor Michael Quay say, yes, the law says it has to be in camera. Everybody else can see the law plain, says it has to be in camera. But there is the need, because of the nature, the public interest nature of this case, to have a public, screening of it. This Chief Justice has been known to regularly allow matters of national interest to be televised. So what she's doing complies with, accords with what we know her to be, correct?
I think when we're talking about the decision she took in some cases to allow for public hearing, that one is discretionary. It's within her powers as head of the judiciary, administrative head of the judiciary, to be able to come to that conclusion. But in this particular case, the Constitution is clear that it shall be held in camera. So in what way that her discretionary powers that were used previously can influence that decision, I have my concerns about that. So
she says you are doing this to protect me. I waive that right. Let it be in public. I want the public to hear what I do and what all of you do to me.
Well, I mean, she can have that say, but at the end of the day, it is not only protecting her. It's not about protecting her, but it's also protecting the institutions and the processes that the Constitution has clearly spelled out here. And so I think that at the end of the day, she might be talking about protecting her integrity or the process, but this is where we are. This is how the system has been set up. And so I think that the system should be allowed to run. Where it's a gray area, then we can talk about the situation can change this way or that way. But as it stands now, in my view, it is clear-cut. So to move forward and push for a change, I think is to frustrate the process.
In the 81-page ruling by the court in the Vincent Appiagyei-Atua, injunction application that was brought up and, dismissed, the court appears to roundly reject, the position that he should have been giving a notice of the petition. The court quotes Justice Framsai, is it the Attorney General? Okay, the Attorney General saying that when Professor Kwekwasari brought his petition in December 2024, the same process was done. It went to, the President took it to the Council of State, I think about 2 or 3 days before she was alerted to also bring her response. And so it is not the case that once the petition came, she should have been notified of it even before it goes to the Council of State, and that cannot be a reason to want to invalidate the process. The question of prima facie, they appear to, through this particular decision, reject these claims. Is that what you see? How you see it?
Yes, Sam, I think I agree with the justices that the majority opinion here, because I think in a number of ways, the problem is with the Constitution itself, the content of Article 146 with regard to the whole process of removal of the Chief Justice from office. And so while there have been some gaps here and there, the Supreme Court itself has come in the Appiagyei-Atua case to clarify some of these points to allow for the prima facie issue to come in. And so the question as to at what point that the Chief Justice should have been informed and at what point should have been given the opportunity to present her side of the story for the president to have made a prima facie determination before the matter would go to the Council of State is something that the court was clear that at the end of the day, the bottom line is that she was given the opportunity. And that does not end the process anyway. There are a number of filters that need to go through. The president receiving a petition, going to the Council of State, the committee being set up. These are all processes which, strictly speaking, do not follow the judicial process as we know it. It's a sort of quasi-judicial arrangement. And that is what the Constitution has put in place. And so going by that process, I think the Chief Justice was treated fairly in being given the opportunity to present his side of the story. And then based on that, the prima facie decision was made. Now we have the committee set up. So why don't we allow the committee to work? But these attempts to frustrate the process, which I think is what is creating the problem that we are in now.